Today's Brandon's blog is titled Inheritance During Bankruptcy, our best answer to how is an inheritance treated in a bankruptcy. Brandon reviews a recent Ontario Court of Appeal decision in the case of Richards REIT. In this decision, the Ontario Court of Appeal sided with the decision of the bankruptcy judge in the lower court of how the inheritance should be treated in this particular bankruptcy situation. And I must say, it is consistent with how inheritances, lottery winnings, gifts, or other windfalls are treated when they're received by an undischarged bankrupt after the date of bankruptcy, but before the bankrupt has been discharged. My name is Ira Smith, president of Ira Smith Trustee and Receiver, Inc. Ira Smith Trustee and Receiver, Inc. remains fully operational. Both Brandon Smith and myself are available to answer any questions you may have, either about this Brandon's blog or anything else at all. So I hope you can watch until the end of this video, because I know you will find it informative. This case deals with an individual named Michael Richards. His parents had set up a trust that stated the family home that the parents had a life lease on. The home was sitting in a trust. And once the second parent died, the trustees of the trust were required to provide Mr. Richards either with the property or, if it had already been sold, the cash. But there was a quirk in the trust document. Michael Richards must have been in financial trouble when the trust document was prepared, because it said his entitlement would stop if he was a bankrupt and would only start again after he was discharged from bankruptcy. Now, Royal Bank of Canada had a judgment for almost $1 million against Mr. Richards, and they went to court to get an order from the bankruptcy court under Section 38 of the Bankruptcy and Insolvency Act. And that section says when a trustee is unable or unwilling to take on an action, a creditor or group of creditors can do so, get an assignment of that action from the trustee, take it on in its own name, and if successful, keep up to the amount of their claim, including the costs of the action. So that's what Royal Bank did. They then went to court to have the court establish that that section of the trust agreement could not be upheld because it was against public policy, and the lower court agreed. Mr. Richards appealed to the Court of Appeal for Ontario. The Court of Appeal for Ontario reviewed the situation and agreed with the lower court that public policy dictated you cannot take an inheritance when received while an undischarged bankrupt that would otherwise be part of the bankruptcy estate for the benefit of the creditors, and try to use some document to contract out of that. So Royal Bank was successful. Mr. Richards was not. Brandon goes through all the details of the case below, and even provides his analysis of how the trust document could have been worded differently, and Mr. Richards could have therefore avoided bankruptcy and instead do a restructuring proposal, have kept the capital of his inheritance, but have to spend a fair bit of it in order to get out of all his debts. But he would have had money left over as opposed to nothing. So I hope you can read the entire Brandon's blog below, because I know you will get value from it. Again, Ira Smith Trustee and Receiver Inc. is fully operational. Both Brandon Smith and myself are holding all meetings by telephone or video, and we've now just started having meetings live again in our office. But we are going to continue with the video meetings because we know people have found them extremely convenient. Again, if you have any questions at all, either about this Brandon's blog or anything else at all, shoot us a message, give us a phone call. We would love to speak with you.